Okay, imagine getting an official notice from an investigating agency, but it pops up on WhatsApp. How do you react? I mean, is that even, legally valid? Let's find out. Welcome to the deep dive. Today we're jumping into a pretty significant Supreme Court of India judgment. It's from July 16, 2025, and it deals with exactly this under the new Haryana Nagarik Suraksha Sanhita 2023, the BNSS. So our mission today is to unpack why the court ruled the way it did on using electronic notices. Basically, can something like WhatsApp be a valid way to serve a notice under Section 35 of this new BNSS? Now, the state of Haryana, they were arguing for it in court. They pushed for electronic service pretty hard. Their points were, well, it stops people dodging notices, saves the government money and time. And look, the BNSS does allow electronic stuff elsewhere, which, the old criminal procedure code didn't really do. So why not for Section 35 notices too? Makes sense, right?
Well, it might seem logical on the surface, but the Supreme Court had a very decisive ruling on this. They stated quite clearly, electronic communication is not a valid way to serve notices under Section 35, period. And a big reason, maybe the primary one, came down to what they called legislative intent. The court saw a conscious omission. They noticed Section 35 wasn't included in the list of procedures where electronic communication is allowed, like under Section 530 of the BNSS. So this wasn't just an accident. The court read it as a deliberate signal from the lawmakers about how these specific notices should be handled.
Okay, legislative intent, that's clear. But you mentioned there was another really big piece to this puzzle, right? Something fundamental. I think it had to do with personal liberty. How did that play in?
Exactly. That was absolutely critical. The court went into quite some detail about why Section 35 notices are different. These aren't just procedural updates. They engage what the court termed substantive rights.
Yeah.
We're talking about fundamental rights tied directly to an individual's personal liberty, which, as you know, is protected under Article 21 of the Constitution. Now, not responding to a Section 35 notice doesn't mean automatic arrest. The court clarified that. But, and this is the key part, it can still have a drastic effect on the liberty of an individual. Because the stakes are so high, the way that notice is delivered has to be, well, rock solid. It needs certainty.
Wow, yeah, drastic effect on liberty. It definitely puts it in perspective. It's not just about convenience then. So the court wasn't just saying no electronics ever. It sounds like they made distinctions.
They did, yes, a very important distinction. They differentiated between judicial acts and executive acts. Think of court summons like under Sections 63, 64, 71. Recalling a witness, those are judicial acts. And those can be served electronically under the BNSS. But notices from an investigating agency under Section 35, that's an executive act. The court explicitly said these two travel on different footings. You just can't treat their procedures the same way. And crucially, they pointed out that if a witness doesn't respond to a summons under Section 71, it has no immediate bearing on the liberty of an individual. Why? That's a stark contrast to the potential consequences of ignoring a Section 35 notice.
Right, okay. That distinction makes a lot of sense. The immediate impact on liberty is the deciding factor there. But with everything going digital, surely the BNSS allows investigating agencies to use electronic communication for some things.
Oh, absolutely. The BNSS isn't anti-technology across the board. It definitely permits electronic communication for investigating agencies in other specific contexts. For example, Section 94. That allows summons to produce documents electronically. And Section 193 covers things like sending investigation reports to a magistrate or, updating victims or informants electronically. That's allowed. But, and the court emphasized this point repeatedly, none of these procedures have any bearing on the liberty of an individual. So it really strengthens the idea that leaving Section 35 out of the electronic service list wasn't an oversight. It was intentional, specifically because of that liberty link.
So wrapping this up, the big takeaway seems to be this careful balancing act, doesn't it? How the legal system is trying to integrate modern tech, for efficiency, but without compromising really fundamental rights, especially the right to liberty.
Exactly. And it leaves us with a pretty significant thought, I think. In this world that's just racing towards digital convenience for everything, how do we make absolutely sure that these core safeguards, these protections for individual rights, remain the top priority? Where exactly does society draw that line?